We're moving on to a new topic, agency law, but don't forget about contracts. The contract law is intertwined through all of the rest of the subjects that we're going to be discussing this semester. So keep the principles in mind as we go through. I'll certainly flag when we're going to be dealing with contracts again, but really it's the underlying basis for a lot of, if not all of the topics that are forthcoming. And now we are going to start talking about agency law. It's one of the most important relationships in the business world, an agency relationship. An agency relationship between two parties. We call one of the parties an agent. They agree to act for the other party, who is called the principal. The principal has the right to control the agent's conduct in matters entrusted to the agent. We see this in a couple types of relationships. Most obvious is the employee-employer type relationship, where the employee acts on behalf of the employer and has the ability to bind the employer legally. This allows principals to do business simultaneously in various locations. That's why they have agency law or agency relationships. Agency law is based out of the common law. It is a state law, so that means that the law varies from state to state. So if you have an agency contract in New York, the laws regarding it or enforcing it may be different than that if it was in California. So, as I said, agency relationships, two common examples, employee-employer, and the second one is we have employer and independent contractor. So an employee is on whose physical conduct is controlled and subject to the control of an employer. If you don't do what your employer says, you can be fired. So the employer kind of controls what you do when you are employed or working under their scope. So Kayla, a salesperson in a department store, is an agent of the store, i.e. the principal, and acts on the store's behalf. So any sale of goods that Kayla makes to a customer is binding on the store. If Kayla makes a representation of fact about a good to a customer, does she create an express warranty? Who would be responsible to the customer of the product? If the customer who bought the product, if the product didn't live up to their expectation based on Kayla's representation, that would be the store. So yes, she has the ability to bind her employer in that sense if she makes an express warranty regarding a product. And the other type of relationship we have is the employer-independent contractor. An independent contractor is a person who contracts with another to do something, but who is neither controlled by the principal nor subject to the principal's right to control with respect to performance. So an independent contractor can be an agent, the other person can be a principal, but whether or not the principal is bound is going to be based on the type of control that the principal has. And for a quick note, because I know it's in the reading material, when you have an employer and employee relationship, there's other laws that kind of come into play besides the agency law, such as employment laws or relationships involving Social Security, workers' comp, unemployment compensation, and workplace safety. All of those kind of come to play when you're dealing with an employer and employee relationship. We are mainly focused on the agency relationship when we talk about it here, but to distinguish between our employee and employer and our employer independent contractor, those types of laws do not come into play if you have a relationship that involves an independent contractor and someone who hires them, or the principal. For example, we have Brooke, who's an owner of real estate, and Brooke hires Tom, who's a real estate broker, to negotiate a sale of her property. So Brooke is contracted with Tom. Brooke doesn't control Tom's work. Tom has to go out and do advertising or knock on doors, whatever Tom, the real estate broker, needs to do to negotiate a sale for her. That's an independent contractor principal relationship. Attorneys may be able to bind a client. So even though an attorney, you may hire an attorney, or you may hire an accountant, but mostly an attorney gets the go-ahead to bind their clients if they're negotiating deals. So you might end up having an agency relationship where the principal is going to be liable, despite the fact that it's an independent contractor / principal relationship. Henry, the owner of real estate, hires Millie, who is an appraiser, to estimate the value of his property. Henry doesn't control Millie's work in that instance. Technically, it's an agency relationship because you have somebody who is hired, an agent, Millie, to do an appraiser. But really, Millie has no business in being able to bind that principal to anything. So you can see the difference between the two. You might have a real estate agent or an attorney acting on behalf of a principal who's and that agent, that attorney, or that broker is the agent. And in some cases, they can bind if they get specific authority to do so. And we'll talk about authority in a minute. Whether a person's hired by another as an employee or an independent contractor, it's going to determine on the employee's status, of course. And what you're really going to look at is how the employer or the principal controls that person. So we move on to classes of agents in accordance with the nature of their relationship. We have 3 different types. We have a general agent. It's a person authorized to assume complete charge of his or her principal's business, or who is entrusted with general authority to act for the principal in all business-related matters. We see this. I like using this type of an example. Is Lady Gaga hires an agent to find her work. That's what an agent does, and that agent is free to go and make contracts on her behalf for performances, for acting jobs, whatever, playing the Super Bowl or singing the Super Bowl. That is a general agent, that agent who signs contracts binds Lady Gaga to those obligations. So they have broad range of powers. And then we have special agents, and I'm not talking about the Secret Service or the CIA. A special agent is one that engages in only one specific type of transaction for the principal, and it limits the scope of their authority. So my real estate broker, my lawyer example, an accountant example, maybe you're just hired to do the taxes for that particular person. Then we have subagents, and subagents are agents hired by another agent. And basically they can't do that without the principal's consent, but we do have this subagents category if in the event that the principal hires an agent to do work, and that requires that agent to hire other agents to help in doing that work. With the principal's consent, they can do so. Puzzle is an exception. There's actually 2 exceptions. Something we call the equal dignity rule. Whenever an agent is empowered to enter into a contract that the statute of frauds requires to be in writing, the agent's authority from the principal must also be in writing. So what does that mean? If we have a contract for the sale of real estate, we know that real estate, based on contract law, we know contracts for the sale of real estate must be in writing. So the principal-agent relationship, i.e. the real estate broker, would also need to be in writing for that contract to be enforceable. The 1 year rule. If a contract cannot be performed in 1 year, then that contract has to be in writing, and therefore the agent-principal relationship needs to be in writing as well. Power of attorneys power of attorneys need to be in writing, and that makes sense. Acting on behalf of powers of another, and you'd never get very far if you walked into a bank and say that you're the power of attorney for so-and-so and you need access to the bank account. That's never going to work. It needs to be in writing. And New York State actually has a standard form that is only acceptable in places like insurance companies and banks. Require it to be on a New York form. Doesn't necessarily, powers of, you can go to Staples and buy a power of attorney packet and fill it out, but there are some businesses in the state of New York that will only accept the standard, the New York Bar Association's standard form. And I put that sample up on Moodle. You could take a look at the sample form. And the power of attorney can have special agent duties where they're only required to perform one thing: handle real estate matters, handle financial matters. It could just be one thing. Or they can be general, where they handle everything. A person authorized by another to act on his or her behalf as a representative, kind of like the Lady Gaga situation. Actually, that's just for hiring and getting her gigs, but you can have a power of attorney that does everything for you. Catherine recognizes that she is not as mentally sharp as she once was and is fearful that she may one day lack capacity to manage her own affairs. Catherine executes a power of attorney, giving James, her adult son, power of attorney. And does a power of attorney have to be an attorney? No, they don't. It could be anybody. But what about this situation? So in this situation, I don't tell you that James is an attorney or not an attorney, but my point is anybody can be an attorney. Doesn't have to be an attorney. There is age requirements on the New York State form of who could be a power of attorney, and that's obviously who can enter into contracts, right? And we're going to talk about minors in a minute, and I am going to come back to powers of attorneys more specifically, but right now we're just talking about the creation of an agency, and the point is these two have to be in writing. So who may appoint an agent? A person with contractual capacity, and what do I mean by that? Going back to contracts. Those who cannot legally enter into a contract directly should not be allowed to do so indirectly through an agent. So who are we talking about here? Who are these people? We're talking about the minors. We're talking about those who lack capacity, who are incompetent, who may be intoxicated at that particular moment. So Junior, a minor who's 17, owns an automobile repair shop. He employs Joe, who's 19, an adult, as head mechanic. Joe contracts with Mid-City Auto Supply for purchase of supplies and equipment. When order is delivered, Junior refuses to accept it. Does he have the right to avoid the contract because he is a minor? You would think, based on that rule that I just told you, that those who cannot legally enter into a contract directly should not do so indirectly through an agent. And here, the minor has employed Joe, who's an adult, to enter into contracts. But can he avoid the contract? And the general rule is that minors who operate a business are bound by the contracts that they make or their agents make on behalf of the business. So they will become bound and obligated to pay the bill. So if they own a business, they're going to pay up. Junior, who's a minor, he's 16. He was employed by Martin's Clothing as a buyer in the young men's department store of a retail store. Junior's duties included making contracts with third parties in the name of his employer. Is this okay? Is the employer bound by the contracts made by this minor? I should ask, is this an agency relationship? It is. We have somebody employing another to work on their behalf. So this is kind of an employee-employer relationship. So it's an agency relationship. Who's the agent? Junior, the minor. Who's the principal? Martin Clothing. So is Martin Clothing bound by Junior's contracts? He is. They are, I should say. They are. And junior can do that. Minors and others who lack capacity may still be considered competent to represent other persons as agents if they are capable of properly carrying out the duties of the agency relationship. And we'll talk about the duties of the agency relationship. So if junior is capable of carrying out the duties that we're going to talk about specifically in a minute, despite the fact he's 16, he can enter into contracts for his principal, and the principal will still be liable. So let's talk about agency by agreement. This is the most common agreement. It basically states the rights and duties of the principal and agent, the duration, or how long the agency is going to last, and any other agreements made between the two parties. Like I said, it doesn't have to be in writing, except for those two exceptions, but it's a good idea to have it in writing. The power of attorney. Under the power of attorney, the agent is called an attorney in fact. And I think I have an example, yep. And when an agent signs for their principal, it would be, so let's say if Nancy Williams is the agent and signs documents on behalf of Susan McGowan, her principal. If you're a general agent, Susan McGowan, by Nancy Williams, agent. So we know that Nancy Williams is the agent for Susan McGowan. When they're a power of attorney, you're going to see Susan McGowan by Nancy Williams, her attorney in fact. That's when we have a power of attorney. Principals, as we know, must be competent to enter into an agreement, because anyone has to be competent to enter into an agreement. And certainly when we talk about a POA, or power of attorney, it must be in writing. And we are going to talk about when the principal who is competent enters into a power of attorney. But then the principal becomes incompetent after that agent has been appointed. People don't understand this relative to power of attorneys, because power of attorneys seem to get people to think that, oh, I'm a power of attorney because this person can't handle their own affairs. Maybe they lack capacity. Folks who are incarcerated have power of attorneys appointed so they can have people act on their own behalf. But we see this a lot more with elderly parents and their children become power of attorneys. So let's talk about this concept. To enter into a power of attorney, that principal has to be competent, okay? You have to be competent to enter into an agreement. But what happens after you enter into a power of attorney and then become incompetent? That power of attorney may be invalidated. That person doesn't get to act on your behalf willy-nilly. You'll see if you pull out the sample of the New York one, there's actually instructions on there that says something to the effect that the power, if you become incapacitated, this power of attorney is voidable or can be invalidated, some language of that nature. What is on that sample you're looking at is a power of attorney. Now we have this concept of durable power of attorney. And a principal executes this document known as a durable power of attorney if he or she intends for the agent's authority to act on his or her behalf, or that the power of attorney that's in effect remains intact in the event of the principal becoming incompetent. That's the durable power of attorney. If you just have a regular power of attorney and your principal becomes incapacitated or incompetent, the power of attorney can be invalidated. If the intention is to have be the power of attorney of somebody who becomes incompetent or is incompetent, they have to be competent when they enter into it. You have to have a durable power of attorney. So we see this obviously in healthcare situations. These are used to give people the authority to act on their behalf if they're incompetent. Some people enter into just durable power of attorneys. They're competent when they enter into. These are our older folks. They're competent, but they know maybe somewhere down the road that they're not going to be competent. They enter into the durable power of attorney when they're competent. that says, when I become incompetent, this person is going to take over as my power of attorney. So the authority doesn't kick in until after the incompetency. So distinguish between those, know the distinction between those two. A couple quick examples relative to agreements, agency agreements. Reese asked Carrie, a gardener, to contact with others for the care of his lawn on a regular basis. Is that an agency relationship? Yes, it is. Reese is our principal. Carrie is the agent. The agent's job is to find subagents to help care for Reese's lawn on a regular basis. Dakota Springs Hotel has Bob, and I'll say that that agreement is an expressed agreement. Dakota Springs Hotel has Bob, who is not an employee, park its guests' cars. The hotel tells Bob when and how to do it. Is this an agency relationship? Even though the hotel doesn't tell Bob what to do? It is. Okay, how is it created? It was implied. How is it implied? The hotel doesn't, by their conduct, are they implying anything? The willingness to have Bob park its customers' cars. And in turn, Bob can infer that he has the authority to act as the hotel's parking valet. So the point being here is that the agreements can be implied or they can be expressed. I make an agreement with you that while you are on vacation, I will run errands for you. One of those errands is to purchase groceries for your return and charging them to your account at the co-op. Is this an agency relationship? It is. We have a principal, we have an agent, and I am binding you to pay for the charges that I made on your account at the co-op. The question is this a valid agreement? Back to contract law, what do you need for a valid agreement? Offer, acceptance, consideration. Do we have consideration here? We do not have consideration here. So my point is, even if there's no consideration, consideration is not necessary to make an agency agreement. This is a gratuitous agency right here. Even though I go and I charge your account for you, you still are, and I bind you, you're bound, you still have to pay for that. You don't need consideration for an agency agreement. Agency by ratification. When the principal, when do we have this? When the principal approves an unauthorized act performed by an agent, or 2, approves an act done in principal's name by an unauthorized person. So you may have an agent, you may have a agency relationship, but the agent did an act that wasn't part of the agreement, and the principal says, yeah, that's okay, like ratifies it. Or you might have someone there is no agency relationship, and they do an unauthorized act in the principal's name, and then the principal finds out about it and says, that's okay. So Greg purchases a camera on behalf of his friend James without his knowledge and consent. Greg asked the dealer to hold the camera until directed to deliver. When James learned of the purchase, what are his options? Well, first let me ask, is this an agency relationship? It's not. Not by these facts anyway. He just purchased the camera on behalf of his friends. It's an unauthorized person type situation. So what are the options? James can cancel the purchase, or he can notify the dealer and say, hey, send the camera immediately. If he does the second option, he notifies the dealer and send the camera immediately, can he get out of the purchase? No, he can't, because he ratified it. So James becomes, once ratified, James is bound by the contract, just as if Greg had full authority to go and buy the camera. James's responsibility dates from the time of the original contract with Greg, not from the time of his ratification. So that's when it kicks in. At the point of when the contract was made, that's when he becomes bound. We're going to talk more about ratification in a second. But this also creates the agency, right? Greg may not have been an agent, but at that point, the ratification created the agency. So ratification is an affirmation of a previously unauthorized contract or an act involving the agent and a third party. And it can be done explicitly or implicitly. Not usually, it absolutely occurs after the fact. The contract obligation was already made. It's done. Is the principal going to ratify it? And if the principal ratifies it, they become bound. And what do you need? You need these requirements in order to have proper ratification. Agent must have acted on behalf of the principal who later ratifies. Principal must know all of the facts. Agent's acts must be affirmed in its entirety by the principal, meaning that the principal cannot accept the benefits without accepting the obligation. Like in that example, James couldn't just accept the camera, but then not be liable to pay for it. Principal must have capacity to authorize the transaction at the time the agent acted and at the time of ratification. So they have to be competent. They have to have capacity. They can't be minor. Principal's affirmation must occur before the third party withdraws or changes position in reliance of the contract. And the principal must observe the same formalities as if the agent acted with authority. So say that there was a contract between Greg and James, that Greg was only to enter into a contract for a camera no more than $1,000, and then this one that he buys is $2,000, and the dealer doesn't know about the cap. Would the principal be liable? The principal will probably be liable as well as the agent because of the unauthorized step here, because we have a plaintiff who's a firm, a principal who has given authority to have an agent act. If he ratifies and says, yes, I'll pay the $2,000, then he has to pay. But we have reliance on the third party, on the agency. And we're going to talk more about that, and I'm going to come back to this example after we speak about the authorities and the duties. But let's talk about another formation. Agency by necessity or operation of law. I kind of lump these together because they kind of go hand in hand. When circumstances make such an agency necessary, an agency is going to be created. We see that in emergency type of situations. We see that for a court to achieve a desired goal. We see that, like, normally family members are not agents for each other, but there are some states that recognize that spouses must support the other spouses. So even if it's against the other spouse's will. So if a spouse goes in and charges an account that the other spouse has for necessities at, let's say, a co-op or a grocery store, the court's going to find that there's an agency relationship. They'll both be responsible for the costs or to pay for the charges to the account. Another example is Linda's car is struck by a train and she is injured. Jake, a railroad engineer, may contact medical care for Linda on behalf of his employer, even though it's not technically his job. His job is to drive the train, but you have an emergency situation. When the agent's unable to contact the principal and the agent's failure to act outside the scope of his authority could cause the principal substantial loss by operation of law. That'll be allowed. And then the desired social policy. A child's parent may not provide for a child with certain necessities of life. Yes, that happens. And what happens is a court appoints a guardian to act on that child's behalf. So I lump those together, agency by necessity and operation, because they're both created by the courts. The courts operate by setting that standard and establishing the agency. And we also have agency by estoppel. When principal's actions or lack of actions creates an appearance of an agency that does not in fact exist, and a third party reasonably believes that an agency exists. So for example, I have it here, yep. Marcus put up a sign outside of Paula's restaurant that says valet parking for Paula's, $10. Paula's never hired Marcus or asked Marcus to do this, but Paula knew that parking was a problem, so she decided not to say anything. Is this an agency relationship? Yes, it's probably created implicitly here, just like the other example. So the question is, if a customer's car is damaged due to the parking job, who's responsible? Or can Paula be? Marcus will be liable. Can Paula be liable? She may be under the theory of agency by estoppel. She didn't hire Marcus or ask Marcus to do this, but she knew that parking was a problem, so she decided not to say anything. I don't say anything here about Paula's control in the situation, but due to the circumstance, if the third party has relied on it or Paula has given the appearance of an agency or that the agency exists, Paula could be responsible for the customer's car being damaged. One last example here. Andrew accompanies Charles to call on a customer, Steve, the proprietor of the general seed store. So Andrew is not employed by Charles. Charles says to Steve that he wishes he had 3 more assistants just like Andrew. This gives Steve the reason to believe that Andrew is an agent for Charles. Steve then places seed orders with Andrew. If Charles does not correct the impression that Andrew is not an agent, will Charles be bound to fill these orders? The answer is yes. Charles represented to Steve creates the impression that Andrew is Charles' agent and has the authority to solicit orders. That's an agency by estoppel as well. So let's talk about an agent's duty to the principal. Duties owed are either set forth in the agreement or they arise by operation of law. The duties are implied from the agency relationship whether or not the identity of the principal is disclosed to a third party. So we have a couple things we have to deal with here. But the duties are performance. An agent must use reasonable diligence and skill in performing the work. This is the example I was telling you about with the miner. You can hire a miner, but that's what they have to do. They have to use reasonable diligence and skill in performing the work. And what is the degree of skill and care required of an agent? What would be expected of a reasonable person under the similar circumstances? There's that reasonable person standard again. Those possessing special skills, such as an accountant or a lawyer, you are expected to use those special skills. Notification is the other duty. An agent must notify the principal of all matters that come to his or her attention concerning the subject matter of the agency. Under agency law, notice to the agent is notice to the principal. So for example, Annette, the manager of a grocery store, is notified of a spill of a gallon of milk in one of the aisles. If she fails to take any steps to clean up the spill and a customer is injured, the store becomes liable. So she needs to, once she received notice, that is the same as notice to the principal. At some point, she's going to have to notify the principal of that issue as well. Loyalty. Agent acts solely to the benefit of the principal, not in his own interests or interests of third party. We call that here's my example from Annette that I just went over. So fiduciary duty, we call that a fiduciary duty for loyalty. Agent acts solely to the benefit of the principal, not in his own interest or interest of a third party. It's a fiduciary duty. So let's talk about Arnie. Arnie is an agent of ABC Insurance. ABC has a customer list that is confidential, and Arnie has a copy of it through his agency relationship. Can Arnie disclose the contents of that list during his agency? No, he cannot. He would be breaching his fiduciary duty of loyalty. After the agency terminates, can he disclose the list? No, he cannot, because he learned that in confidence through a confidential agency relationship. So he would still be breaching his duties after the fact. Gail asked Kurt to sell her Kindle e-reader on Craigslist. Can Kurt, that should be buy, B-U-Y, not buy. Can Kurt buy the Kindle without Gail's consent? No, he cannot. Kurt cannot buy the Kindle without Gail's consent. That would be a breach of duty. Agent makes authorized purchase order from Megacorp as a token of its appreciation. Mega provides 2 tickets to a sporting event for agent. Does the gift of tickets need to be disclosed to the principal? Yes, it does. If not, well, one, we've breached the requirement of notification of all matters concerning the subject matter, or breach of loyalty. The agent solely acts for the benefit of the principal, not his own interests. So he would have to disclose those tickets to the plaintiff, otherwise would be in breach of that duty. MARTA, a salesperson for roadway supplies. Knife River Construction gives MARTA a new tablet as a gift for prompt deliveries of roadways paving materials. The question is, who owns the tablet? And before you can answer that question, I have to tell you about the other 2 duties that were on the list prior to this. We have obedience. The agent has the duty of obedience. When acting on behalf of the principal, the agent must follow all lawful and clear stated instructions of the principal. But as I said, under operation of law, they have an exception, which is in emergency situations. If the principal can't be consulted, stands to suffer a loss, the agent can deviate from that. And then the last duty is an accounting. The agent must keep and make available to the principal an accounting of all property and funds received and paid out on behalf of the principal, including gifts from third parties, and they can't commingle their personal and agent accounts. So back to MARTA. Who owns the tablet? The principal owns the tablet. This is part of her agency duties. She has to apply an accounting. The new tablet may be a gift. Knife River may have intended it to go to MARTA, but MARTA has to, 1, disclose it to the principal, and it is a principal gift. If the principal then decides to give it to MARTA, that's up to them, but the owner is the principal. So now the principal's duties to the agent. They're either expressed in the agreement or they're implied by law. Compensation. Principal has a duty to pay agent for services rendered. Agreed upon amount. If there's an agreed upon amount, that's what they have to pay, or if no amount is agreed upon, the principal owes the agent the customary compensation for the agent's services. So whatever's customary based on the agency relationship. Reimbursement and indemnification. If agent disperses funds at the request of the principal or pay necessary expenses in the course of performing duties, the principal must reimburse the agent. The principal must also indemnify or compensate an agent for liabilities incurred because of authorized acts, as well as for losses suffered by the agent or others because of the principal's failure to perform his duties. For example, if an agent orders supplies on the principal's behalf and the agent is held liable for the payment, the principal must indemnify or compensate the agent for the liability. And then the last is cooperation. A principal must cooperate with the agent and assist the agent in performing his or her duties. The principal must do nothing to prevent the performance under the relationship. So if Peggy creates an agency with Don, which allows Don to sell Peggy's products exclusively in one area or territory, can Peggy be held liable to Don if she permits another agent to sell in that territory? Yes. And what could Don sue for? Maybe loss of sales. And I should note right here that a principal does not owe the agent any fiduciary duties. There is no duty of loyalty on the part of the principal to the agent. Those are the 3 duties of the principal. Agent of authority. The agent's authority. The liability of a principal to third parties with whom an agent contracts depends on whether the agent has the authority to enter into legally binding contracts on behalf of the principal. So does the agent have authority to enter into legally binding contracts on the principal's behalf? That's the question you have to ask when you are looking at a scenario. An agent may perform only those acts that have been authorized by a principal or a court. If the agent exceeds the authority, he can become personally liable unless the unauthorized act was reasonably assumed by a third party to be within the powers delegated to the agent. The third parties can justifiably assume that the agent has the authority to act. So if that's the case, so too can the agent be justified in assuming that he or she has certain authority to act, not specifically act in a way that's not specifically stated in the contract. We're going to talk about those examples in a second. So the authority of the agent, it can be expressed, it can be implied, and it can be apparent. So let's start with expressed authority. What do I mean by expressed? It's specifically stated in the contract, right? The authority actually given by the principal either orally or in writing, it's specifically stated. For example, Zoe orally asks Parker to sell a ranch that Zoe owns. Parker finds a buyer. Her name is Gloria, and signs a sales contract on behalf of Zoe to sell the ranch. Is this an agency relationship? Yes, it is. Parker's our agent. Zoe's our principal. Can Gloria enforce this contract? Gloria, our third party? I hope you're not saying yes, she can, because the answer is no, she can't. Why not? What kind of contract is this? It's one for the sale of land. Zoe orally asked Parker. We don't have anything in writing here. It's in violation of the statute of frauds. So equal dignity rule, remember that one from a few moments back? Has to be in writing. So unfortunately, Gloria cannot enforce this contract because the contract needs to be in writing. And because the contract needs to be in writing, the agency agreement needs to be in writing. I know that was a trick question. So implied authority. Agent reasonably assumes he or she has the authority. Authority an agent reasonably assumes he has that relates to the expressed authority granted by the principal. Can also be implied by any custom or inferred from the position that the agent occupies. So let's talk about this example. King owns several hardware stores and hires Smith to manage one of the stores. King tells Smith that Smith is in charge of the personnel at his store, but that King is the exclusive purchaser of inventory for the sale. Do we have an agency relationship? Yes, we do. It's kind of an employee-employer relationship here. We have the principal King, we have Smith, the agent, and Smith's position is he's the manager of one of the hardware stores. Do we have express authority? What's the express authority? That Smith can hire and fire employees for the store he manages. That's the express authority. What can he do? He can't buy inventory. That's King's job. Is there any implied authority here? He's the manager of a hardware store. What do managers of stores do? They sell They could be selling merchandise, enter into contracts that a manager would normally have in his situation. It's not expressly stated here, but if he's working at a store, he's ringing out customers and he's selling products. Maybe he's making express warranties. This saw can cut through stainless steel. Who knows? But if he's acting in a way that's reasonable for someone in that authority, then he's going to be acting in his agent capacity as under implied authority. And if he does, in fact, give an express warranty, King could be liable. And I will say before I skip to apparent that you may have read in the book that you might see express and implied authority also called actual authority. But I like to separate them out in the two distinctions. So apparent authority comes from a third party's reasonable but mistaken belief that the agent has actual authority to enter into a contract. So remember Marcus who put up the sign outside of Paula's restaurant that says valet parking for Paula's $10. Paula's never hired Marcus and asked Marcus to do this, but Paula knew that parking was a problem, so she decided not to say anything. Is this an agency relationship? By Estoppel, right? If it's reasonably believed by a third party. Does Marcus have any authority? Would we call it apparent authority? Because a third party's belief, those customers who come for parking, it may be mistaken, but the belief that the agent has the actual authority to park cars. So in this case, we have a agency relationship by Estoppel, and we have apparent authority. He has apparent authority to act because of the third party's reasonable belief, or their belief is reasonable. Kevin, the assistant manager of a sporting goods store, offered customers a 25% reduction on the prices of all merchandise in his department store during an end-of-season sale, despite the fact that the authority to change prices was limited to the store managers. Sherry tries to cash out at the store the items she got on sale. Does the store have to honor the reduced prices? And the question is going to turn on whether or not the third party's reasonable but mistaken belief that the agent has actual authority to enter in the contract. Is it reasonable that customers would assume that Kevin had authority to reduce prices? If so, bound by the doctrine of apparent authority, which means the store would have to honor those reduced prices. Liability for agents' contracts. The principal. All right. Generally, a principal is responsible to third parties for all agreements made by the agent on behalf of the principal if the agent acted within the scope of his or her authority. You may even see if it's not within the scope, in the scope of their employment. We're going to use that interchangeably. They must act within the scope of their authority/employment. And the liability will relate to things like contracts and relate to things relative to torts like negligence, but we're going to talk about liability for agents' contracts right now. So in determining liability for a contract formed by an agent, it's going to turn on whether or not the principal was disclosed in some way to the third party. So disclosure of the principal. So we have a disclosed principal. That's the obvious one. The identity is known by the third party at the time the contract is made by the agent. That's the easy one. Partially disclosed principal. The identity is not known by the third party, but the third party knows that the agent is or may be acting for a principal at the time the contract is made. And then we have an example of a partially disclosed principal. Sarah has contracted with Paul, a real estate agent, to sell certain property. She wishes to keep her identity a secret, but Paul makes it clear to potential buyers that he's acting in his agent capacity. That is a type of undisclosed principal, partially disclosed principal. Now we're on undisclosed principal, and it is what it says it is. The identities of the principal is totally unknown by the third party at the time of the contract, and the third party has no knowledge that the agent is acting in an agent capacity. Okay? So our rules are when dealing with contractual liability, we're going to ask what authority did the agent have to enter into a contract with third parties, and was the principal disclosed? Now these are our rules relative to liability. If the agent is acting within the scope of his authority, i.e. contracts with third parties, and you have a disclosed principal, the principal is liable, the agent is not, to any problems relative to the contract, any breach of contract, any payments on the contract, that sort of thing. If you have a partially disclosed principal, both the principal and the agent are liable. And if you have an undisclosed principal, the agent may be liable, and the principal is liable unless principal was expressly excluded as a party to the contract, that the contract is a negotiable instrument. I know we haven't delved into the world of negotiable instruments yet, but let's say like a check. The contract is a negotiable instrument and it's a check, and there's no indication that the agent is acting in a representative capacity, meaning that the agent can just go and cash the check. And performance of the agent is personal to the contract, such as the agent is a musician and it's a contract requiring that person to give a concert. Those are the liabilities depending on the disclosure of the principal. If the agent is acting outside the scope of their authority and principal does not ratify, then it's the agent that is liable to the third party. Okay? Completely liable to the third party, unless the third party knew the agent was acting outside the scope of authority. So, those are our rules relative to liability. When dealing with the contract issues, you're going to ask yourself those questions to determine who is ultimately liable. And if the agent is acting within the scope of their employment, you're going to be asking these questions. If they're outside the scope, then they're personally liable. Principal is not, unless the third party knows that the agent is acting outside the scope of authority. So we have Martin. Martin entered into a contract with Stoneyard Incorporated to install flooring at Blue Ridge Farms, a food manufacturing facility in New York. At the time, Martin indicated that he was acting as an agent, but did not disclose that he was acting as an agent for the farm facility's owner, Blue Ridge Foods, LLC. When Stoneyard was not paid for the work, it filed a lawsuit in New York State Court against the farm facility, its owner, and Martin. And the question is Martin, who's the agent, personally liable on the contract? And the answer is yes. He's acting as an agent, partially disclosed principal, and the principal remained undisclosed, right? Well, he disclosed that this was an undisclosed principal, and who remained undisclosed, even though he indicated he was acting as the agent. So let me rephrase that. Is Martin personally liable on the contract? Yes, he is. He is acting as an agent with a partially disclosed principal. The principal remained undisclosed. We call this partially undisclosed because, one, principal is not disclosed, but Martin is saying he's acting as an agent. So here, as an agent for an undisclosed principal, Martin has liabilities. So the answer is yes, he is still liable under the contract, and he can be sued as well. Hopefully that was clear. If you don't, shoot me an email and I'll say it again. So liability for agents who commit torts. Okay, generally a principal is liable for the torts and crimes of the agent if they are committed at the direction of the principal or while the agent is performing unauthorized is performing authorized duties during the ordinary course of the agency. So that's our rule. If an agent makes a fraudulent, for example, if an agent makes a fraudulent statement in a contract within the scope of authority, the principal is going to be responsible. Fraudulent misrepresentation, as we've learned, okay? Tort liability arises when the conduct of the agent creates a loss for a third party. So they can arise from carelessness or negligence, or intentional conduct, purposeful conduct, intentional tort, like that example of fraudulent misrepresentation. And those things intentional torts can sometimes be crimes as well. So, who's liable in those situations? I said generally it's the principal, but let's kind of break this down here. First off, an agent is always personally liable for their tort and their crime. Okay? Always. A principal is liable if committed within the scope of the agency, or the employment. We call this the doctrine, fancy term, respondeat superior. Respondeat superior. And it's Latin, and it means let the master respond. So this doctrine, it's like a strict liability, because the principal isn't doing anything. It's the agent, right? So it's like a strict liability. It imposes vicarious, is the word, or indirect liability on a principal without regard to personal fault of the principal for the torts committed by an agent in the scope of their agency. So if Dan, the employee of a delivery truck firm, negligently runs a red light and injures Kate, a pedestrian, is his employer liable? The question is whether a particular activity that the employee or agent engaged in is within the scope of employment in the agency. Has nothing to do with authority here. Are they acting within the scope? Yes. If he's delivering the truck during business hours that he's working, and he runs the red light and he hurts Kate, the employer will be liable. Okay, a couple more examples here. We're almost through this. Mike is having a cup of coffee at work. He accidentally spills hot coffee on a client during a business meeting. The client suffers burns. Is this within the scope? Well, is Mike liable? Yes, he is. All agents are liable for their torts. And this is accidentally spilling hot coffee on a client who gets burnt. Is the principal liable? Yes, because it's within the scope of the agency or employment in this case. So the answer is yes. After work, Mike stops at Starbucks to grab a cup of coffee. Mike happens to see a client sitting at another table and goes over to say hello. Mike, having a bad day with his coffee, accidentally spills his hot coffee on the client. Is Mike liable? Yes, he is. Agents are always liable. Is his employer liable? No, because this is after work, after hours, not within the scope of his employment. After a business meeting, client expresses concerns with being able to tell the cab driver where his next destination is. This is a client from out of town. So Mike, bringing his hot coffee with him because he can't let his coffee go, escorts the client out of the building. But the employer has a policy that employees cannot leave the building without permission during working hours, and Mike doesn't get permission. And while he is hailing a cab for a client, Mike spills his coffee on the client, burns the client, and the client sues. Is Mike liable? Yes. Agents are always liable for their torts and their crimes. Is the employer liable? That is the question. And the answer is yes, because his actions are related to work, and Mike is furthering the interests of the principal by assisting this client. Oh, what if Mike said, nope, sorry, I can't help you out, cab driver, because I can't leave the building? That probably wouldn't fly very well, right? So in this instance, if it's work related and he's furthering the interests of the principal and a tort occurs, then the employer could be held liable. And intentional torts, P is liable if the tort was foreseeable and within the scope of the agency. You don't see much of the intentional torts. But here's an example. A bouncer at a bar pushes an unruly patron in an attempt to get the patron off the premises. Is the bouncer liable? Yeah, the bouncer is liable for an intentional tort. You can't put your hands on anybody. If for a tort, we're suing. We're suing somebody for money. So that is considered a battery when you intentionally push somebody. Maybe you learned that. I think you may have learned that in the torts part of your business law 1 class. Had this person got hurt after the fact, that's a whole different animal. But yes, bouncer would be liable, and the employer would be liable because it's certainly foreseeable and within the scope of the agency that a bouncer would put their hands on somebody. So this is an example of that. Termination of the relationship, of the agency relationship, like any other contract, it can be terminated by agreement, performance, or operation of law. Those operation of law items: death, incapacity, it's impossible, bankruptcy, a change in circumstances. We'll go through a couple examples. But a lapse of time under the agreement may specify a reasonable time, may say this is going to expire on such and such a date. And either party can terminate it. Purpose achieved, when the employed for a specific objective to sell real estate and the property is sold, it's done. The agreement, performance, it's done. An occurrence of a specific event, agency created to terminate on a particular happening. Maybe an agent is acting for the principal while the principal is on vacation, and then the principal returns. It ends. It can be terminated by agreement. Either party can terminate their relationship. And I should say, even though they have the power to do this, they may not have a right, depending on the contract. The contract might say, and this contract remains in effect for 6 months, and somebody terminates it in 3. There might be some breach options there. You have the power to terminate it, but you may not have the right. And like I said, on operation of law, death, incapacity, impossibility, bankruptcy, changed circumstances. Changed circumstances, when an event occurs that has such an unusual effect on the subject matter of the agency that the agent can reasonably infer that the principal will not want the agency to continue. For example, change of circumstances. I want to say that again. When an event occurs that has such an unusual effect on the subject matter of the agency that the agent can reasonably infer that the principal will not want the agency to continue. So Carter hires Ray, a real estate agent, to sell a tract of land, and then Ray, the real estate agent, learns that there's oil under the land, greatly increasing the value of the tract. Be sure that's an understanding there that Carter isn't going to want to continue to sell the land, or maybe he will, but he wants a lot more money. And the bankruptcy. Either party files for bankruptcy, you have a termination. So the last piece of this is the duty to notify. Who has the duty to notify third parties? The principal. When an agency terminates by operation of law, though, there is no duty. Nobody has to notify any third party. But if the parties terminate, it's the principal that has the duty to notify the third parties that the agency no longer exists. There is no particular format in doing so. They can put an ad in the newspaper. They can send letters to folks that they assume know that this agency exists. They can state it to individuals expressly, but it's up to the plaintiff, the principal, to notify of the termination of the agency.